All rise. The Supreme Court of Guam is now in session. The Honorable Robert J. Torres presiding.
Good morning, councils. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-007, People of Guam Plaintiff Appellee v. Branty Walliby, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Nathan M. Tennyson. Appearing for Defendant Appellant is Attorney Terry E. Timblin. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, Associate Justice Catherine A. Merriman. Your Honor, Attorney Timblin reserves 5 minutes.
Mr. Timblin, you may proceed.
Chief Justice Torres, may it please the court. This is kind of I don't have a whole lot to say about this one, but the issue of sentencing for first offenders has been floating around the Superior Court for years, and there never has appeared to be a consensus by either the Attorney General or defense counsel or the judges about how to apply Section 8031 as opposed to Section 8030. In my experience, it has mostly been assumed that Section 8031 applies when the rap sheet is empty or there is no rap sheet. At the same time, if the rap sheet shows a prior conviction, or at least a felony conviction, the defense counsel has mostly assumed, and as I have, that Section 8030 applies without arguing any need to plead to prove it. There was either a prior or there was not.
There are a couple of decisions that have been issued by appellate courts. You pointed out, of course, the Joshua decision, where the court stated it was 8031 was unambiguous. And then the people relied on People v. Solace, which was a district court appellate division that's binding on the trial court, or is it persuasive and binding on the trial court unless there's good reason to depart on it. Why don't those cases control? Is there a reason we should depart from those cases? Something different in those cases that we didn't look at?
Well, again, first of all, as I pointed out, neither case, both were dicta that there was one was within the statute, the first offender guidelines. One, he wasn't a first offender.
So you think that both of those cases didn't address the ultimate issue that was just dicta of the court, and therefore stare decisis should not necessarily guide our analysis?
I believe that this is the first time it has been truly and cleanly presented to the court. But as I said, there's also not only there is a lack of consensus on the trials at the trial level, but there was a lack of consensus within the Attorney General's office, as demonstrated by this case. Mr. Brown, in drafting a sentence memorandum, assumed that 8031 applies, and he asked for 15 years. Ms. Tenorio, who appeared at the sentencing, argued otherwise. If Mr. Brown had appeared at the sentencing, we probably would not be having this conversation. As I indicated, this is really the first time it's been squarely presented. I think it is the only sensible interpretation of what the legislature intended was that the first offenders be treated more leniently than repeat offenders. I believe it is.
How do we glean that legislative intent? What can you point to that would help us arrive at that conclusion that that's what the legislature intended?
That I'm sorry if you could speak up a little bit. I got,
Yeah, you said that the language of the statute suggests a legislative intent to treat first offenders differently from repeat offenders. And uh, what can you point to that will help support that that is really what the legislature intended? I mean, you don't disagree that there is an ambiguity when both statutes, 8031 and 8030, has both the may and the shall language that seemingly creates the issues that we have before us.
well, just in terms of, I guess my basic argument is that the greater power already implies a lesser power. If you can give somebody 20 years under 8030, we have the power even under 8030 to give them 15 years. And so it kind of renders, so if you say, okay, well, also you can, if you want, you can also give them 15 years instead of 20. But the judge already had that power in the first place. You give them between nothing and unless there's a mandatory minimum, you can give them anything between nothing and 20 years. If you can give them 20 years, you can give them 15, which I believe that renders 8031 superfluous. And I think as your previous pronouncements have indicated that you do not appreciate or do not like the idea of having rendering a one statute essentially, again, superfluous. If you read it a certain way, it means nothing. If you read it another way, it means something.
The argument that, excuse
Go
me, the argument that the government seems to make is that 8031 is permissive, discretionary, and we really should leave it to the trial judge who will be presented with the facts of the sentencing hearing, and the trial judge should be given the discretion to decide whether 8031 or 8030 applies, depending on the facts of the case. And some of the examples in the brief is that there are considerations like this particular case. You know, there's an egregious circumstance in terms of the actions of the defendant, and first-time offenders are not necessarily less, I guess, they can be more offensive than repeat offenders in reference to the activities that in which how the crime was committed, and that we should leave it to the trial court to decide based on the particular facts of the case.
Well, if overall, it's the statutes, criminal statutes normally tend to punish first offenders or repeat offenders more than first offenders. Like I said, if you look at the drunk driving statutes, first offense gets you 48 hours minimum. Second offense gets you 7 days. Third offense gives you 30. There's other statutes out there, but I mean, it's just.
What about if, you know, the argument that you can have a first offender that is just, you know, so violent in terms of how the crime may have been committed, and in this particular case, facts, person was already on the ground unconscious, and there was a repeated assault of the victim, and someone like that, even as a first-time offender, may not necessarily warrant the more lenient sentence.
Well, again, there's classifications, categories of crime. Some are considered more serious than others. Like in this case, Mr. Walliby had convicted of murder. He'd been looking at 15 to life. Again, I think there's overall, again, there's a tendency in the law to you either did this particular offense, I guess you can do it any number of ways, maybe worse, some worse than others, but the law says, and under this statute, you get this much murder, and if you get this much, it's manslaughter, but again, it just ultimately, it just doesn't make any sense. It renders, if you can give them 20 years for manslaughter, you can give them 15 just as easily. That's basically, all I can do is repeat myself, that overall, with apologies to Johnny Cochran, the more you offend, the more you spend. That's been my way of looking at things my entire career. And again, I submit that 8031 becomes just meaningless if again, you're giving the 8031 doesn't give the judge anything that he didn't already have.
Well, I was trying to understand your position on that, because you said that if the power to sentence a defendant to not less than 5 years and not more than 20 years necessarily includes with it the power to sentence a defendant to not less than 3 and not more than 15. That didn't make sense, because how do you get to the power to sentence a defendant to less than 3 when the power that you've just cited previously was to sentence him to less than 5? I mean, the minimum is there, and it's a totally different minimum. I understand the argument that says, well, if a judge can sentence someone to not more than 20, sentencing him to not more than 15 is encompassed with it, and the maximum term might be superfluous. But I don't see how your argument that the minimum term is superfluous holds water.
Well, I get the but my main concern is with the maximum. The minimum, it might be some meaningfulness.
Yeah, so it doesn't mean that the statute itself is entirely meaningless, because there is a provision for the minimum terms in there that are not that the judge doesn't have the discretion on in 8030.
Yeah, but also, yeah, well, yeah, my main concern basically is more with the maximum.
So is it your position that the statute's ambiguous, or it's plain and meaning, and the plain meaning is the way you want it to be, and that it's mandatory? I mean, because I think whether it's ambiguous or not, elucidates how we can evaluate the statute.
Well, I don't think it's really ambiguous, but if it is, normally it's if there is ambiguity, normally it goes in favor of the defendant. But again,
well, I'm asking you if you think it's ambiguous.
I personally do not think that it is ambiguous, if you wish. It's just,
Well, how do we reconcile?
I got it. Just that I'm just looking at the overall scheme that if greater power implies lesser power. That's really.
But how do you reconcile? You say that 8031 is not ambiguous. When and the introductory part of 8031 says that if someone has been convicted of a felony for the first time, he may be sentenced to imprisonment as follows. And then A says that the court shall impose a sentence. And in the first instance, the statute says the court may, which suggests that that's discretionary. And then
it depends on how you treat may. I think you can treat may as saying, this is all you may do, period. You may go this high and no higher. That's my thoughts on the subject. Again, looking at 8030, it does say, how do I put it? Except otherwise provided by law. And I submit that one thing that is otherwise provided by law is 8031. So that But well, basically 8031 does not say anything except as otherwise provided by law. So I think that's further indication of the legislative intent that
But if it's unambiguous, well, how can we look at legislative intent?
well, I can only make certain inferences that again, there's no exception under 8031. You shall, when a first offender, you can, if the first offender, give this much, or nothing about you can otherwise provided by law, unlike 8030. All I can do is make inferences from how the statutes read, and he said, I'm just asking that the court take another look at what has been said by this court and by the appellate division. And keeping in mind that, again, normally the tie or an ambiguity goes in favor of leniency to the defendant. And
So you interpret the phrase may as follows, meaning these are the options that the court has for sentencing, and it's limited only to those options.
yeah, basically, so again, this is what you may do. And I think that's the way it should be interpreted.
What if the court decides it doesn't want to do that? Because you said the court it may do. What if the court says, I'm not going to follow this?
Well, that's what appeals are for. That's why, again, my position basically is that all that, in this case, that Judge Tolentino may do was give him 15 years. And if you disagree, you can come up here and see what
No,
what they say.
I'm asking, I'm struggling. So I'm asking for help in reference to help me try to clarify what the legislature may have intended and how it structured the language of the statute. That's what I'm struggling with.
Well, at this point, I can only repeat myself pretty much that how you constitute what does may mean, I think it means one thing. And the fact that 8030 says basically this is what's happened, except that it's otherwise provided by law. And of course, there's a zillion different sentencing statutes for specific offenses. Whereas 8031 doesn't say that. And I think that I can't make it any clearer than I've already said. I think it's that may means this is what as far as you can go. And that's pretty much it. Wish I could be more help, I guess, but there's again, if it is ambiguous, then it should be decided or in terms of leniency rather than severity. That's all I can say.
All right, you have 7 minutes remaining, Mr. Timberlake.
That's again, I think it's pretty straightforward argument. I can't really add to it. So I've reserved some time, but we'll see what happens.
All right. All right, you've reserved and you'll have 7 minutes remaining. Mr. Tennyson?
Thank you, Chief Justice. May it please the court. I think the real issue we have here, and I agree with Attorney Timlin on the interpretation of the may. I think it's, well, and we have mandatory mays and discretionary shalls. It's a may, it's a permissive may. And I know there's been some pushback on the people, including 8032 because of 8038 and Murtaugh. And for purposes of when I refer to that, I'm assuming that notice has been given that there's no unconstitutional violations, that it's been the violation was noticed in the pleading and a jury found it. And this is just for example, because I think when we're looking at the language of the structure, these were all intended by the legislature to function together. So even though one has some problems with it because of Apprendi and Murtaugh, or Murtaugh, it's still helpful in determining the structure and the analysis of what this is doing. So 80-30, I mean, except as otherwise provided by law, the court may enter a sentence. And then if it does this option under 80-30, it has its shall requirements for the duration based on the severity of the crime or the felony. And we go to 80-31, which says if 80-30 is applicable for someone who's not been previously convicted, and it's their first time of a felony, they may be sentenced. So people's interpretation here, and Salas is helpful here. And the main reason we cite to Salas is it's, they're exercising the same power this court had. They're not binding on you, but I think they do a good textual analysis and they dig into it, and I appreciated their interpretation.
But in Salas,
Yes.
whether the terms of 80-31 were discretionary or mandatory wasn't really the dispositive, because they were looking at whether the government had to prove the prior conviction before this defendant could have been sentenced under 9 GCA 80-30. So
correct. And as to the holding, I agree with that. It's really more to take out some of the reasoning and the analysis of the sections in question, less for its authority in that sense. But when we trigger 80-31 how people view this as, well, the court now has either 80-30 or 80-31. It may sentence under either of those after review of the underlying factors. And under this kind of analysis, I agree the legislature has put into its statutes that first-time offenders can receive some discretional leniency. There's discussion of, well, why is it in there? It's redundant of 80-30. The court could, in its discretion, do that anyway. I think by having the additional statute, the legislature has said, this is a factor we want you to look at.
But isn't that what the range supports or is for? 5 to 20, 5 to 15. This is the discretionary factors. By giving the range that the trial judge is given the discretion. But as Mr. Timblin points out, to treat repeat offenders the same way as first offenders, there's nothing that is clearly stated in the statutory scheme.
Yes. Just 1 second.
I mean, so you can collect your thoughts. I mean, there needs to be a reason and rationale why the legislature provided for a range of 5 to 20 under 830, 5 to 15 under 831. And so, but that is not determinative as to which statute applies under different facts of the case.
Correct. And as to that, I mean, all I can do is speculate as to what the legislature was doing. When I've been looking at it, it seems like they partitioned it. I mean, we have 80-30 as your starting point, and then from there you go further in and you find other options. And really, I mean, if we were looking at 80-31 as a legislative statute saying, a first offender shall be sentenced this way, I mean, my hope would be that when they drafted it, they would have said that, because there's that initial may in there, I would have hoped would have been a shall, that a person who's been previously convicted and is a first time a felon may, or rather shall be sentenced. Because then if we go back up to 80-30 and we see except as otherwise provided by law, then we have that except is unless it's a first time offender, in which case you shall do this. But in the may is really where these things stick. I mean,
but couldn't that may be interpreted to say, these are the options if you're a first offender? You have option 1, 2, and 3. And so it may sentence it in this way.
Yes.
Although, I look at 80-31 and they use shall in A, shall in B, and then, but then in C they used may also.
The shalls and mays are sprinkled liberally without. And I think that's really the challenge of looking at this. And that's why when I was looking, I bring in the 80-32, because if we're looking at this from this May of this kind of mandatory May of, if you hit this particular circumstance, this is your sentencing statute. If it's a first time offender, you hit this. If it's under 80-32, a repeat offender who has been charged properly, who has hit all the requirements, then you shall sentence under this, regardless of it saying maybe, you cannot use 80-30, you have to use 80-32. And the court has no discretion. And if the statute was worded that way with a shall, I'd say, okay. But I think once we take this may and say, well, it's a mandatory may.
But they never used shall in the 80-32 subsections. In contrast to 80-30 and 80-31, the legislature never used the shall in the 80-32.
And that's correct. And that's, at that point, we're going from, logically, we're going through gates of, you may do this, it's optional, then you go through the gate, but you shall do this if you choose this option. And to that point, if we're looking at 80-31 in the court.
What about the argument that if we treat 80-31 as merely permissive, then that maximum term ends up being superfluous? You don't need it, right? They could have just drafted the statute to say you can impose a sentence of not less than 3 years, not less than 1 year. But because you really don't need and not more than 15 years, you've already found that that power in 80-30.
And as to that, I'm not entirely certain.
Which I may suggest that the may, pardon the pun, may suggest that the may is really a mandatory may rather than a permissive may in 80-31.
And that is a potentiality. My concern with the mandatory may is, I appreciate there's always exceptions. It's been presented that, well, 80-31 is superfluous. If we say it's a mandatory may, I think 80-30 becomes more superfluous because you're either a first time or you're not. And if it hasn't been charged properly, you're going to be deemed a first time offender because we can't just I don't think you can just hold against someone. Well, actually it's conviction. That's okay under Apprendi.
Yeah, that's right.
That would be okay. Never mind.
Yeah.
So that would be fine.
I don't think by finding 80-31 as mandatory would necessarily mean that 80-30 would render it superfluous.
I think so. There would be a healthy subsection that we could identify. So I withdraw that argument. That's a good point to raise on that. Regarding the legislative intent, without diving into the records on it, which I haven't done, I think the biggest indicator of legislative intent we have is, Salas has been out. The court made a comment in Joshua, and Salas came out in the 80s, I believe. The legislature has never amended this. They've never updated it. And whatever the holding, if Salas had been totally off point in saying that this is not a discretionary thing, it's a mandatory thing, I think the legislature would have come in and said, no, we intended that first time felons should be treated to a lower sentence. And I think the legislature might want more discretion than that. And I think you can find the discretion in here if you want to find it. If you want to find an alternative, you can find that too. Is at the end of the day, the judge is the one that sees a lot of it, hears a lot of it. There's a question of, I view this as a mitigating factor as its intention. You could have a first-time felon who is just so egregious. If the statute says that the minimum is 15, it's 15. But if it is discretionary, the judge has the ability to look at that, even for a repeat offender, has the ability to look at that and say, under these circumstances, there are or not mitigating factors. I incorporate that in my sentence. I review all that. And since you're a first-time felon, I do find that and it's appropriate, maximum 15, I'm going to go less. Or despite the fact you're a first-time felon, in this case, the judge really did dig into the situation, letter from the parents. The defendant spoke on his behalf. The judge looked at it and had serious concerns about alcohol abuse and future conduct by the defendant. And that was really a basis. All those total,
But
yes.
as Mr. Timlin points out, I mean, you have
Mhm.
7 judges downstairs, 8 judges downstairs. There needs to be some structure
Yes.
and uniformity in reference to what are the parameters.
Mhm.
Within the parameters, the judge is free to use its knowledge and skill
Mhm.
to exercise his or her discretion. But when a first offender comes before, there needs to be some indication as to what he or she faces.
Mhm.
And the argument is that 8031 provides that you will get no more than 15 years because that's what the legislature prescribed.
Mhm.
And in order to give, number one, notice to defendants, number two, to treat differently, maybe from a community sense, policy sense,
Mhm.
repeat offenders as opposed to first time offenders.
Mhm.
So if you stand back and you'll look at the big picture, there seems to be rationality in that because when I mean the language, we're going to have to sort this through, but
Mhm.
we're you have to just stand back and look at, we got different trial judges who has bring different experiences,
Mhm.
and so you don't want such a disparity
Mhm.
depending on which judge you come before.
Correct. And I mean, there's concerns about judicial resources too, of then having this court need to review certain issues. And I also agree that I believe this is a good opportunity to have a strong standard. Now, what direction the standard goes in really is subject to the unpacking of the language of these statutes.
Do you think 80-30 is mandatory?
I think that,
I mean, your position obviously now is 80-31 is permissive. What about 80-30? I mean, they use the same language.
yes, if I was the one making a decision and I was looking at these, my interpretation is that 80-30 is the general statute from which my primary authority stems from. And if I deviate from that, I need to have another statute. Now, if I'm looking at 80-31, if I read those in tandem, I say, because of the may, and I agree the may is subject to some interpretation if it's mandatory or if it's you can have fish or chicken. I mean, in that sense of pick one and then take the path you're assigned. I would say that, I could sentence to 20, but if I was inclined under 80-31, if it was a first time offender, I could go under 15. Now, is that superfluous? Yes. But I don't know if the legislature was considering that or if they were just saying, we want to have a policy that, this is a factor we look at.
Because if we take 80-30 as being mandatory based on the language that's there, except as provided by law, you may be sentenced like this. And so it's mandatory that the court impose a sentence of not less than 5 and not more than 20. And on. And if we take that as being mandatory and they use the same language in 80-31, the exact same language, it would seem to suggest that they also meant that to be mandatory. So if you're a first time offender, it's mandatory in the sense that, like you said, it's fish or chicken. You follow these options. You're limited only to these options, and that's what you can choose from. It.
Okay, and that is definitely I believe that's a reasonable interpretation. I mean, I think they're both potential reasonable interpretations. My only caution on that would be if we do that kind of mandatory may that, and I don't know what the impact on 80-32 is or other statutes within sentencing, but I think if you do that, then any statute that has that same may construction needs to be afforded that same kind of mandatory. If you go down, if you start at 80-30, because I would say it's mandatory unless you have an option. And I would say the options are options of the court. I think the other option there is it's mandatory unless you're funneled into another mandatory may. And then once you're there, court's discretion is solely limited to these ranges. So if you're a repeat, you can't look at 80-30. You can only look at 80-32. If you're an 80-31, only 80-31. You can't look at 80-30. So I would say, in so far as we use that mandatory interpretation, it just needs to be applied equally across the board. And we should, I've tried to analyze some of the impact of that, but I'm not sure totally what that might imply.
And I think it is a reasonable read to read it in two ways, which might suggest there's some ambiguity that we have to look to the legislative history and ascertain legislative intent.
And I think the court has the gist of the issue, and really what the crux is, and the people have offered the best assistance and guidance they can. I think Salas has the reasoning and analysis are okay. They're good. They're reasonable. There are other ways of looking at it. And, I think the people here would just say, having discretion can help with these kinds of things. I know there's good reason for being stuck into kind of a more rigid expectation system of, okay, you're going to be in this range. But that notice is here kind of already. And I always just think of outlier cases that I can't think of examples for, where you might want some discretion and not want someone to either be at this 15-year minimum for a first offender or this wider range. And I appreciate the court does have leniency in there. So maybe that addresses that concern.
And
But-
also, I mean, 80-32, although it's not immediate relief, if the concern is this is, the way the crime was committed is such an egregious crime, he gets 15 years because he's a first offender. But it really made sense that he should have gotten more. I mean, if he doesn't reform in prison, the Department of Corrections can always come in and petition
Yes.
to increase the sentence. That's not the end of it.
Yes. And that is that's a good observation. Particularly in regards to the policy and the direction that a decision might go. I think less for, unless they drafted them with this together, but those are really the issues that people wish to raise. Do I have any other notes?
But just last,
Yes.
thoughts. I mean, the argument that the government is making here is that we should give the trial judges the discretion to select, based on the facts of the case, whether 80-30 or 80-31 applies. And I mean, an example is within your own attorney general's office. There, was a difference of interpretation. In the first sentencing memorandum is 80-31 applied. And then a different lawyer comes and says, no, it's 80-30. And so that calls for some type of uniformity in reference to which statute applies, and not just, leave it to the individual judge, leave it to the attorney general as to how he or she reads it. And that it should make sense that there is some structure as to, depending on the circumstances, what statute applies, and not just leave it to the discretion of the individual AG or assistant attorney general or the specific trial judge.
Yeah, I agree with that. I mean, my assumptions are generally based on, if people can charge for something or go for the full, that's what's being done. If lessers are being done, particularly, the shift from we're going under 80-31 and shifting to 80-30. That's a different scenario than the one I initially contemplated. But that, as you indicate, does point to needing clarity as to what standard is appropriate. There could be confusion as to 80-31 and 80-30 being mandatory paths, or an option for the judge. And, first time offender, if the judge finds that's a suitable mitigating factor, is automatically, it's 5 years off the maximum. What's the practical implication of that statute? If it's redundant with the judge's, authority already, other than just, hey, we want to put focus on this. I'm not certain. But it really just comes down to how the court wants to interpret the maze and look at all this combined. And at this point, I've covered all the main issues we wanted to address. And if there's no further questions, I would just request that the court review the statutes and make a determination and adopt the guidelines so we have some certainty going forward and we can proceed.
Justice Merriman has a question.
This isn't the only part of the sentencing scheme.
Mhm.
There's certain crimes that have mandatory
Mhm.
sentences. Does that affect how we interpret these particular sections? Or does it just stay out of the discussion?
I would, it's going to depend on how those are worded. If I had one, I could look at off to make a determination. It would help. I think it's going to hinge on,
Well, for example, in the same range of homicide,
mhm,
a deliberate murder has a life without parole.
okay, yes. I think what the controlling factor there is, if we look at 80-30, the except as otherwise provided, because then we're looking at each statute and contingency to see, do we hit this? Do we match that? So we hit a particular crime that has a mandatory sentence. And I expect there we would find the statute says, if you commit this crime and are found guilty, you shall be sentenced to X. And I'd say that's probably a mandatory shall. And I would say that probably I'm just following my gut. I'd say that overrides 80-30, 80-31, because it's otherwise provided by law. Regardless of if you're a first-time felon or not, if you commit capital felony and murder, that statute mandatory would control.
Thank you.
All right. Thank you, Mr. Tennyson.
Thank you.
Mr. Timberland, you actually have 12 minutes, not 7 minutes. The clock was started to account for the 5 that you reserved. I don't think you'll take all 12.
I will not take 12, just a couple of things. Again, no matter what your honors decide this morning, eventually decide, it'd be helpful to get this clarified because it's not, they said, been at this a long time. I've seen a lot of cases, a lot of sentencings. And again, nobody really seems to be sure about where the line's drawn. Also, just point out that if Judge Tolentino had given Mr. Walliby 25 years, which is 5 years over what 80-30 allows, I think it would have been a slam dunk reversal on this point in this court. And I'm just asking that 80-31 be treated the same way.
All right, Mr. Timberland, thank you. Thank you, Mr. Timberland. Mr. Tennyson, the court will take the matter under advisement, will issue a written opinion, and will now stand adjourned.
All rise.
Hey, thanks.